Alright, Natural Resource Code, Title 3, Subtitle A, Administration, Chapter 81, Railroad Commission of Texas, Subchapter A, General Provisions, 81001, Definitions, Chapter Commission means Railroad Commission of Texas. 2. Commissioner means any member of the Railroad Commission of Texas. Act 1977, the 6th Legislation, Public Law 25508, Chapter 87.1. Article 1, Section 1, effective September 1st, 1973. Section 81002, definition of person for certain provisions in this chapter. Person includes a corporation as provided with the Section 312011 Government Code, and the definition of person assigned with the Section 311005 Government Code does not apply. Added Acts 2009 81st Legislation, RS Chapter 85, SB 1540, Section 3.01, effective April 1st, 2011. Alright, Subchapter B, Administrative Provision, Section 8101001, Subset Provision. The Railroad Commission of Texas is Chapter 325 of the Government Code of the Texas Sun Act. Unless continued in existence and provided with the chapter of this commission abolished September 1st, 2029. Railroad Commission of Texas shall pay for the costs incurred by the Sunset Advisory Commission performing a review of the commission under the section Sunset Advisory. Commission shall determine the cost of the commission, shall pay for the amount of those costs properly on the receipt of the statement from the Sunset Advisory Commission detailing the costs. Add Acts 2009 81st Legislation, RS Chapter 85, SB 1540, Section 302. And then continues Section 8101002, Chairman. The Commissioner selects each. This Commissioner shall elect one Commissioner as the Chairman. Section 81003, qualification to office of the Commissioner must be qualified voter under the Constitution and laws and at least 25 years of age. Section 8101004, Personal Finance Disclosure Standard Conduct Conflict of Interest. Commissioner is subject to the provisions Chapter 572 of the Government Code that apply with elected officers, including the requirements general governing personal finance statement, the standards of conduct, conflict of interest added with the Acts 2009. Section 8101005, Name and Seal. The Commissioner are known collectively as the Railroad Commission of Texas. The seal of the Commission contains a star of 5 points with the words Railroad Commission of Texas engraved on it. Section 8101006, Procedure Rule. The Commissioner may adopt all the rules necessary for the Commission, government, and the proceedings. Acts 2009. 8101007, Supply. The Commissioner shall be furnished necessary furniture, stationery, supply with the expense of it to be paid for on the order of the Governor. Section 8101008, Session. The Commissioner may hold sessions at any place of the state with the considered necessary. Acts 2009. 8101009, Records Research Fee. The Commission shall charge a person request for the examination search for the Commission. Records are $5 for each half hour, with a fraction half hour that the Commission employee spends for the examination search unless person requesting search represents for the state and for the county, added within the Acts 2009. Section 8101010, Fee for copies. The Commission may charge for the fee for copies for the papers provided by the Commission to a person other than the Department of the State. The fee for a copy of paper, the document of the record of the Commission office, including the certificate seal, to be applied with the Secretary, and 15 cents for each of the 100 words. Section does not authorize the Commission to charge the person a fee for a tariff sheet for the person's own use if tariff sheet is ineffective. In effect. The fees charged and collected under this section shall be accounted for the Secretary of the Commission, paid into the Treasury as provided in the Chapter 603 of the Government Code added in Act 2009. 8101011, Method of making payments to Commission. A. The Commission may authorize payment prescribed by the Commission regulatory fee with the fine, penalty of charge of the goods. Certificates means of electronic payment method of credit card issued by the financial institution chartered by the state or the United States or issued by the nationally recognized credit organization approved by the Commission. A payment by the authorized method may be made in person and telephone through the Internet. Commission may require a person who makes a payment to the Commission means of the electronic payment method or credit card due pay a discount, service charge fee, and amount of the reasonable and necessary to reimburse the Commission for the costs involved in processing the payment. The Commission may adopt the rules necessary to implement this section added in Acts 2009. 8101012, Gifts, Grants, and Donations. A. In this section of the contents contested case. This means for the assigned section 2001-003 Government Code. The Commission may apply for the request of the solicitor with the contract to receive and accept of administrative gifts, grants, for the donation of the money, or other assistance for any source to carry out with any Commission purpose for the power. C. That the Commission may not, under subsection B, accept a gift of the donation of the money or property for the party contested with the case during the period of the inception of the contested case until the 30th day after the date of the final order signed in the contested case. And that was added in Act 2009. Section 810101.3 Conflict of Interest. In this section, Texas Trade Association may be the cooperative, the volunteer, with the joint associate for the business professional competitors in this state designed to assist with its members of the industry or profession dealing with mutual business professional problems and with the promoting of their common interests. A person may not be employed with the Commission, employed with a bona fide executive administrator with a professional capacity as a phrase for the purpose of establishing exemption overtime provisions of the Federal Fair Labor Standards Act of 1938. At 1, the person is an officer or employee paid with a consultant of the Texas Trade Association and a business or an industry regulated by the Commission. The person spouse of the officer of the manager and paid consultant with the Texas Trade Association and the business and industry regulated by the Commission. C. A person who is required to register as a lobbyist under Chapter 305 of the Government Code may not act as a general counsel for the Commission. D. The Commission shall provide with the Commissioners to agency employees as often the necessary information regarding the requirements of the office of employment under the chapter, including the information regarding the person's responsibility under the applicable laws relating to standard of conduct of the state officers employer added in Acts 2009. Section 810101.4 Equal Opportunity. Equal Employment Opportunity. A. The Commission shall prepare and maintain a written policy statement that implements the program with equal opportunity to ensure that all the personal decisions are made without regard to race, color, disability, sex, religion, age, of the national origin. The policy statement must include personal policies, include the policies relating to the recruitment, evaluation, selection, training, with the promotion of the personnel that show the intent of the Commission to avoid the unlawful employment practices described in Chapter 21 of the Labor Code. 2. Analysts for the consent with which for the Composition Commission personnel in accordance with the state and the federal law with a description reasonable method to achieve the compliance with the state and federal law with the policies the statement must be updated annually, be reviewed by the Texas Workforce Commission Civil Rights Division compliance with the subsection B detailed with the Governor's Office added Acts 2009. 810101.6 Separation of Responsibilities. The Commission shall develop and implement policies and clearly separate the policy-making responsibilities of the Commissioners and management responsibilities of staff of the Commission added in Acts 2009. 8101.1 Chief Supervisor. Commissioner shall employ the Chief Supervisor for the Oil and Gas Division to assist the Commission with enforcing laws relating to the production, transportation, conservation, oil, gas, and rules ordered by the Commission adopted under these laws. Chief Supervisor also shall perform the duties of the pipeline experts others to provide for the pipeline laws of this state. Acts 1977, 8101.2 Qualification of Chief Supervisor. In addition to the other qualifications that may be required by the Commission, person appointed Chief Supervisor must have had at least 5 years' experience in some line of the oil or gas business and some of the other business or profession that would be provided with the necessary knowledge and experience for the performance of the duties. Acts 1977. 8101.3 But the duty supervisor, assistants, and clerical personnel of the Commission may be appointed with the Chief Deputy Supervisor, Deputy Supervisor, Assistant, and clerical personnel necessary for the execution of the laws relating to oil and gas. Acts 1977. 8101.4 Qualification. Chief Deputy Supervisor. The person appointed with the Chief Deputy Supervisor must have had at least 3 years of experience in the oil and gas field work. 8101.5 Qualification. Deputy Supervisor. Any of the person appointed with the Deputy Supervisor must have had at least 2 years experience in oil and gas field work, including substantial experience with the drilling and production. Acts 1977. 8101.6 Salaries. The salary of the Chief Supervisor, Chief Deputy Supervisor, the Deputy Supervisor should be the same as provided in General Appropriations Act of 1977. 8101.65 Sales of salary of the Secretary. Salary of the Secretary of the Commission shall be the amount appropriated for the purpose of the legislator. Acts of the 2009. 8101.7 Additional employee with the Commission may be the employee with the gougers, inspectors, investigators, supervised with clerical employees. But these employees must include with the Chief of the Engineer, Chief Petroleum Engineer, Administrative Chief, but their salaries shall be paid with the amounts provided with the General Operation Act of 1977. 8101.8 Payment of salaries for the other expenses of the salaries for the other expenses necessary for the administration enforcement over the oil and gas laws shall be paid by warrants drawn with the common control of the state treasury for the general revenue. Warrants with experience that shall be issued on duly verified statement of the person entitled with the funds signed with the approval of the chairman of the commission, 1977, amended to the Acts 2015, 81019, duties of the chief supervisor, chief deputy supervisor, and other employees. Chief supervisor, chief deputy, and supervisors, deputy supervisor, and other employees shall perform the duties described in this commission in the conformity with the rule of the commission relating to the production, transportation, and conservation of crude oil and natural gas, Act 1977. Section 81020, additional duties, chief supervisor and his deputies. Chief supervisor and his deputy shall supervise the plugging of all abandoned wells and shooting of the wells shall have the file of the rules of the commission relating to the production, conservation of oil and gas. B. The chief supervisor shall gather information to the commission of the performance of the duties under Title Acts 1977. 81021, intellectual property for the commission may 1. Apply for the fee for register, secure, hold, and protect under the law of the United States, of the state, of the nation, of the patent of their invention, of the discovery, the improvement of any process of manufacturing, machining, and composition of the matter. B. A copyright of the original work for the art or authorship, the fixed for the tangible medium of the expression known with the later developed from which it can be perceived, or reproduced, or otherwise communicated with either directly or with the aid of the machinery or the device. C. A trademark for the collective mark with a certification mark for a word, name, symbol, device, or slogan that the commission even identify with the distinguish the commission goods, services with the other goods and services. D. The other evidence of the production inclusivity of the issue of the intellectual property contract with the person with the sales, the lease, of the marketing, other distribution of the commission's intellectual property. 3. Obtaining under a contract and signing a subdivision, royalty, license right, other appropriate means of the securing reasonable compensation for the development of the purchase of the commission intellectual property. And 4. Waive the reduce the amount of the compensation secured by the contract under subdivision 3 of the commission determines that the waiver or reduction will be A. Further a goal of the mission of the commission. B. Result in the net benefit of the state. B. Money made with the commission under this section shall be deposited for the credit of the oil and gas regulation cleanup of the funds as provided in section 81067 and added in Acts 2017. Alright, subchapter C, jurisdiction, powers, and duties. 81051, Jurisdiction Commission. The Commission shall have the jurisdiction over the common carrier pipeline of the defined section 111002 of the Code of the Texas Oil Gas Well of the Texas. Person owning or operating pipelines in Texas and person owning and engaged with drilling, operating oil, gas, and wells in Texas. Be a person listed in subsection A of the section of their pipeline of oil, gas, and wells are subject to the jurisdiction conferred with the laws of the Commission, Acts 1977. 81052, rule of the Commission may adopt all of the necessary rules governing regulating the person to the operation under the Jurisdiction Commission set forth in section 81051, including such rules of the Commission may consider the necessary appropriate to implement state responsibility under any of the federal laws rules governing such a person and their operation, Act 1977. Alright, 810521, fee for application exemption of the Railroad Commission rule. With each application for the exemption to any of the Commission rule contained in Chapter 3 of the Part 1, Title 16 of the Texas Administrative Code, the application shall submit to the Commission a fee of $150. The application fee with exemption of any of the Commission rules will not be refunded for the proceed with the fees with excluded. Any penalties collected with the connection with the fee shall be deposited for the oil or gas regulation cleanup fund as provided in Section 81067. Acts added in Acts 1985 and amended with the Acts 2001. Acts 2011 and 2015. Section 810522. National Gas Policy Act application fee A. With each of the National Gas Policy Act of the Title 15 United States Code Section 3301 through 3432 for the application submitted to the Commission a fee of the Commission shall set for the application fee of the amount necessary to cover the cost of the Commission well category determination program but not to exceed $150. The fee for a natural gas policy application may be not refunded. Amended in 1985 and amended within 2001. Section 810523, exclusive jurisdiction and express preemption. In this section, commercial responsible for being with the condition that would allow the reasonable, prudent, operating, fully effectively, economically exploit the development, produce, the process, transport oil of the determined based on the object for the standards of the reasonable, prudent, operative, not only individual assessment of actual operator capacity to act. 2. Oil and gas operation means an activity associated with the exploration, the development, the production process, for the transportation of oil and gas, including with the drilling, hydraulic fracture, stimulation, completion, maintenance, reworking, recompletion, disposal, the plugging, and abandonment, and the secondary territory recovery and remediation activities. An oil and gas operation is subject to the exclusive jurisdiction of the state, except as provided in subsection C of the municipality, other political subdivisions may enact, enforce ordinance for the other measure for the amendment of the revision of the ordinance for the other measure for the ban, limits, and otherwise regulate for the oil and gas operation within the boundaries of the territorial jurisdiction of the municipality and political subdivision. C. An authority of the municipality or other political subdivision regulate oil and gas operation expressly with a preemptive, except with the municipality may enact, amend, and enforce ordinance other than measure than that. 1. Regulates only above ground activity related to the oil and gas operation that occurs above the surface of the ground, including the regulation covered in front of the emergency response with the traffic lights and noise, and or imposing notice of the reasonable setback requirements. Is commercial reasonable? Does it have the effect of the prohibited oil and gas operation conducted with a reasonable, prudent operator? And is it not otherwise preempted by the state or federal law? An ordinance for the other measure for the concern of the premio officia is to be commercially reasonable for the ordinance other than measure that has been effective for the last 5 years and has allowed the oil and gas operators to issue and continue during that period. Acts amended in Acts 2015. Section 81053, Commission power of the discharge is for the duty of the enforcement of the jurisdiction of the title of the Commission shall institute suits, hearing determination, complaint with the required with the attendance of the witness and pay for their expense of the output out of funds provided for their purpose of obtaining the legislation for the writs and process of which may be necessary for the enforcement of its orders, punishment of the contempt, disobedience, and its orders and manner provided with the district courts. Acts 1977, 81053-1, administrative penalty. If the person violates the provision of the title pertaining to the safety of the prevention of the control of the pollution, provision of the rule, order, license, permit, and a certificate with the pertain to the safety or prevention of the control of the pollution, or is issued under the title of the permission may be assessed with a civil penalty by the Commission. Penalty may not exceed $10,000 a day each violation that has not related to the pipeline safety, $200,000 a day each violation that is related to the pipeline safety. And each day of B1, each day of violation continues, it may be considered with a separate violation for the purpose of penalty assessment provided with the maximum penalty may be assessed and related series. Violation related to pipeline safety management may not exceed $2 million. And determine the amount of the penalty for the Commission with the job to consider the permitter's history of the previous violation with a series of the violation has with the health and safety of the public with the demonstration of the good faith of the person charged, and determining the amount of the penalty for the violation of the provision of the title of the rule, order, license, and permit, or certificate that relates pipeline safety. The Commission shall have the consider of the guidelines adopted in subsection D. The Commission may, by rule, shall adopt the guidelines to be either determine the amount of the penalty of the violation provision for the title of the rule, order, license, permit, certificate that relates to the pipeline safety. The guidelines shall be penalty calculation worksheet for the specified with the typical penalty for the certificate violation, circumstances for justifying the enhancement of the penalty with the amount of the enhancement of the circumstances justifying reduction of the penalty amount of the reduction. The guidelines shall take into account permitter's history of the previous violation, include the number of the previous violations, here the number of the violation, and any of the pollution resulting from a violation, any hazard to health and safety of the public, the degree of the culpability, and the demonstrated good faith of the person charged, and 6, any other factor of the Commission with the consider of the relevant in A. A penalty collected under this section shall be deposited for the credit of the oil field cleanup fund in Acts 1983 and also amended in 1999 and amended in Acts 2013. Section 81053-2, penalty assessment procedure. Civil penalty may be assessed only after the person charged with the violation described under Section 81053-1 of this code has been given the opportunity for the public hearing. If the public hearing has been held with the Commission shall make findings of the fact and shall issue the written decision as to the occurrence of the violation, amount of the penalty that is warranted, incorporating with the appropriate with the ordering the requirement of the penalty to be paid. If the appropriate with the Commission shall consolidate with the hearings with the other proceedings. If a person charged with a violation fails to avail himself of the opportunity for the public hearing, civil penalty may be assessed with the Commission after it has determined that violation did occur and the amount of the penalty is warranted. Commission shall then issue an order requiring that the penalty be paid. 81053-3. Payment of penalty refund on the issuance of the order finding that the violation has occurred, the Commission shall inform the person charged within 30 days of the amount of the penalty. Within the 30-day period immediately following the day of which the decision order finally was approved, the subchapter F of this chapter 2001 Government Code that the person charged with the penalty shall pay the penalty in full if the person seek for the judicial review either for the amount of the penalty, in fact, of the violation, or both for the forward amount of the commission for the placement of the escrow account in lieu of the payment of the escargo posted with the commission supersede with the bond with the form of the proof of the commission from the amount of the penalty, such bonds to be in effect until all of the judicial review of the order decision is filed. If through judicial review of the decisions are ordered to determine if no violation occurred with the or the amount of the penalty shall be due for the non assessed, the commission shall within 30 days period immediately following that determination, if the penalty has been paid with the commission, remit the appropriate amount to the person with accrued interest, or where superseded bond has been posted, the commission shall execute the release of such bond. Third, to forward the money to the commission within the time provided in subsection B, but the section results in the waiver of all legal rights to contest the violation of the amount or the amount of the penalty. Judicial review of the order of decision of the commission assessing the penalty shall be under the substantial evidence of the rule shall be instituted by the filing of the petition within the district court of the Tavis County, Texas, and not elsewhere, as provided in subchapter G of chapter 2001 Government Code and Acts of added acts in 1983, amended in 1995. 810534, recovery of penalties, civil penalties owed under section 810531 through 33 of this code may be recovered with the civil action brought by the Attorney General with the request of the Commission added to the acts in 1983. Section 81054, enforcement by Attorney General, with the Attorney General showing forth the provision of the title by with the injunction or other adequate remedy with the other provided with the law. If an action is instituted with the Attorney General under the section alleging violation of the NPDES permit with the failure of the obtainment of the NPDES permit, Chapter 91 and Chapter 141 of the Natural Resource Code, the Attorney General may not oppose the intervention by a person who is standing to intervene as provided in Rule 60 of the Texas Rules of Civil Procedure, Acts 1977. Amended Acts 1995. 810505, Pipeline System Financial Responsibility. Requirements. A, repealed in Acts of 2011. If the legislature found with the adoption such of the requirement that desirable the commission by rule may require an owner, operator, or manager pipeline system obtain the evidence of financial responsibility, the rulers must specify the appropriate form of the amount of the evidence of the may require the evidence of the financial responsibility in different amounts of the different pipeline system taken into consideration whether the pipeline system one, has a history of the discharge or other violation of the regulatory requirements. 2, is located over the public drinking water supply. Natural resource, a critical groundwater resource for the need of the school or populated area. And that's added in Acts 2001, amended in 2011. 81056, contamination report. In this section, the common order carrier has a meaning assigned by the section 111002. Owner of the land and landowner means that the first person who is shown the appraisal of the role of the appraisable district of the establishment of the county of the tract of the land is located with the owning of the interest into the surface of the state of the land at the time of the contamination report is required to be made under this section. B, if the process of the placing of the repairing and replacing the maintaining of pipelines common to carry with the owner and operator of the pipeline observe to detect any of the petroleum-based contamination, soil, water, proximity of the pipeline with the common carry with the pipeline owner, operator shall report the contamination to the commission of the owner of the land over which the pipeline is located with the petroleum-based contaminants of the soil of the water that is observed and detected is required to be reported under this subsection. If 1, hydrocarbons were present in the surface of the water. 2, that at least 5 years linear yards of the soil have been affected with the hydrocarbons. 3, soil affected with the hydrocarbons extend beyond the face of the excavation which contamination is observed and detected. The contamination report must be made but not later than 24 hours after the common carrier of the pipeline owner of the operator observes or detects the contamination. 2, that must include the global position satellite with the coordinates for the location of the contamination. 3, may be made by telephone, fast amount with electronic mail. D, no later than the 3rd business day after the day of the commission receipt of the contamination report, the person authorized by the commission shall withdraw with the soil with a sample from the contaminated land of the person is entitled to enter the land for the purpose of withdrawing a sample to the common carrier of the pipeline owner of the operator must make for the contamination report under this section release from the all liability for contamination of the cleanup of the contamination covered by this report, except for any of the contamination covered with the common carrier of the pipeline owner and operator. The commission shall adopt all the rules of implementation of this section. The commission may use money the oil field cleanup fund to implement this section. The amount of the money in this fund commission may use and for the purposes may not exceed the amount of the money is funds that is derived from the fees collected under this section. 91-142 for common carriers, owners, operators, pipelines as determined annually by the Commission and added to Acts 2005. Amended to Acts 2009. Alright, Section 8105, 7th Exemption Certification Purchase Rule. The Commission is not required to follow any of the purchase procedure for the prescribed under Subchapter E of the 22155 of the Government Code for the Commission make for the purchase of the connection with remediation surface of the location of the well plugging adds Acts 2003, amended to Acts 2005 and 9. 81058, administrative penalty, certain natural gas related activities. A, the Commissioner, after the notice of the opportunity for the hearing, may impose the administrative penalty against the purchaser for the transportation, gatherer, shipper, and seller of natural gas person described in Section 81051A and 111081A. Any other entity within under the jurisdiction of the Commission under this code, the Commission determines that violated Commission rule adopting standards over the code of conduct and even the natural gas industry prohibiting unlawful discrimination of 2. Unreasonable to discriminate against the seller of the natural gas or the purchase of the natural gas from the seller. The Commission, after the notice of the opportunity for the hearing of the may impose the administrative penalty against the purchaser, transporter, gatherer of the natural gas, if the Commission determines that the person engaged in the prohibited discrimination against the shipper of the seller of the natural gas because of the shipper or seller file the formal informal complaint with the Commission against the person relating to the person's purchase of the transportation gathering of the gas. C. The Commission, after the notice of the opportunity of the hearing of the may impose the administrative penalty against the purchaser of the transport, gather, shipper, or sale of the natural gas, who, the party of the informal complaint with the resolution proceeding, is determined with the Commission to have failed to participate in the proceeding, failed to provide information requested by the mediator within the proceeding, and administrative penalty imposed under this section may not exceed $5,000 a day for each of the violation. Each day of violation continue for the curve of the separate violation for the purpose of the imposing the penalty under this section. If the Commission determines after the notice of the opportunity of the hearing of the entity that has engaged in prohibited discriminated with the penalty that may be imposed under the section, the Commission may issue an order necessary with the reasonable to prevent the discrimination from continuing. The remedy provided within the section is cumulative in any of the other remedy with the Commission's may order acts added in 2007. Section 81059, appointment of mediators for informal complaints. The Commission may provide with the appointment of the Commission staff member of the mediator with informal complaints over the Commission. The parties may agree to employ with the pay of the independent mediator for the purpose of the mediating of the complaint. B. The parties request for the mediation for the contact with the location of the other than the office of the Commission of the Austin, and the parties shall reimburse the Commission for the Commission's costs related with the travel to the other's location. C. This section does not prohibit the Commission from the requirement of the party to participate in the formal complaint resolution proceedings. D. At least annually, the Commission shall notify oil of the gas procedure for the existence of any formal complaint resolution. Process provided by the Commission. The filling of the informal complaint is not prerequisite for the filling of the formal complaint. 81591, complaints. The Commission shall maintain a file with each written complaint with the file with the Commission. The file must include the name of the person filed with the complaint, with the date of the complaint is received by the Commission, subject matter of the complaint, with the name of each proof of the contact with the relation for the complaint, with the summary of the result of the review of the investigation of the complaint, examination of the reason for the file, with the code of the Commission, code of the file, without taking action other than investigation complaint with the Commission, shall provide with the person filing with the complaint, each of the person subject to the complaint, with the copy to the Commission policy of the procedure relating to the complaint and investigation resolution. The Commission, at least quarterly, until finally with the deposition of the complaint, shall notify the person filing with the complaint, with each of the persons subject to the complaint of the status investigation life of the notice would be jeopardized with undercover investigation. 810592, consumer interest in information of the Commission shall prepare for the information for the consumer interest for the describing the regulatory function of the Commission and of the procedure with the consumer complaint without within result by the Commission. But B, the Commission shall make the information available to the public and appropriate state agencies. 81060, confidential provisions. A, the confidential provision may not require the contract for which the producer is party for the sale of the transportation gathering of the natural gas that is entered into or after September 1st, 2007. Confidential provision, a contract in which the producer of the party for sale of the transportation or gathering of natural gas was entered into before September 1st, 2007, because unenforceable on the day of the term of the contract expires, added in Acts 2007. 81061. Authority to establish market-based rates. This section does not apply with the rates established under Chapter 103 of the Utilities Code, Subchapter C or G with the Chapter 104 of the Code. The Commission may use the cost of service method or market-based rates method in setting the rate of the formal rate of proceeding. On the filing of the complaint with the shipper herself of the natural gas of the Commission may transport with the gathering of the rate of the formal rate proceeding in the Commission determines the rate with the necessary remedy for the unreasonable discrimination of the provision of transportation gathering served with the Commission with the may set for the rate with regardless of whether the transportation or gathering is classified as a utility or other law by law. Added Acts 2007. 81062 the Public Participation Commission shall develop and implement policies that provide for the public with a reasonable opportunity to appear before the Commission and to speak on any issue under the jurisdiction of the Commission. Added Acts in 2009. Section 81063 issue suspension, revocation, license, permit, and certificate. If the Commission purpose of the suspend of the revoke the person's life of the permit of the certificate of the public conveyance of the necessity of the person is entitled to hearing before the Commission may not with the review of the license issue of the license permit of the certificate of the person because of the person's race, religion, color, sex, or national origin. 2. Revoke the suspended license permit, certificate, or person because of the person's race, religion, color, sex, and national origin. Adds Acts 2009. Section 81064 of the power of the Commissioner of the designated employee within case before the Commission. In case before the Commissioner of the unauthorized Commission, employee with a designated by the Commission for that purpose in the same manner as an entire Commission where present may hold a hearing, conduct an investigation, make a record of the hearing and investigation for the use of the benefit of the Commission. 3. 4. The administrator and the oath. 5. The certified by the official act. And 5. 6. Compelled by the attendance of the witness and the production of the papers and books and accounts and other pertaining documents and testimonies. The record of the hearing and investigation made under this section of the certified by the Commissioner and employee have the same effect as made before the Commission. The Commission shall determine the case of which the record made under this section is in the same manner as the record have been made before the Commission. The Commission may punish for the contempt of the person who refuses to comply with this section, obstruct with the attempts of obstruction and proceeding under this section. Acts added in 2009. Section 81065 of the Alternative Dispute Resolution Policy. Commission shall develop and implement a policy that encourages the use of the appropriate alternative dispute resolution procedure under Chapter 2009 of the Government Code to assist in resolution internal and external disputes under the Commission with the jurisdiction of the Commission with the procedure relating to the alternative of the dispute resolution must confirm to the extent possible that any of the mutual model guidelines that issued by the State Office of the Administrator with the hearings for the use of the alternative dispute resolution by the state agencies. Commission shall coordinate implementation of the policy adopted in subsection A with the provide for the training of the need for the implement of the procedure for the alternative of the dispute resolution. 3. Collect information concerning the effectiveness of the procedures acts added in 2017. Section 81066 of the Oil and Gas Division Monitoring and Enforcement Strategic Plan. With the Oil and Gas Division Commission shall develop and publish an annual plan for each of the state of the finance. Each state official year of the oil and gas monitoring enforcement resourcement force of the Commission for the strategically ensure the public safety without protecting the environment. The Commission shall seek the input of the stakeholders when developing each of the plan. The Commission shall collect and maintain information for the accurately show the Commission's oil and gas monitoring enforcement activity. Each annual plan must include a report of the information collected by the Commission that show the Commission's oil and gas monitoring and enforcement activities over the time. D. The information described in subsection C must include the data regarding the violation statute for the Commission rule for the rate of the oil and gas included, the number, the type of the severity of a violation of the Commission found to have occurred. B. The violation of the Commission referred to from the enforcement of the section of the Commission responsible for the enforcement, and C. The violation for which the Commission imposed the penalty for the took over the enforcement action. Number of the majority violation for the which the Commission imposed the penalty for the took out of the enforcement action. 3. The number of the repeat major violations categorized for the individual oil or gas lease. If applicable, the Commission shall publish each of the annual plan over the Commission Internet website not later than July 1st of each year, preceding the state official year, with the Commission implementation of the plan added in Acts 2017. Section 81067, the Oil and Gas Regulation Cleanup Fund. The Oil and Gas Regulation Cleanup Fund is created as an account with the General Revenue Fund for the State Treasury with approval of the Acts 2019. The funds consist of proceeds from bonds, other financial security required by the chapter beneficial under the well-specific plugging insurance policy described in Section 9104C. They are paid with the state of the contingency beneficiary of the policy subject to the refund provision. Section 91091, if applicable, the private contribution included the contribution made under Section 89084. Expenses collected under Section 89083. Fees imposed in unit 85-2021. Costs recovered under Section 91457 and 91459. Proceeds collected under Section 89085 and 9115. Interest earned over the funds deposited in the fund for the oil, gas, waste of the hull or permanent action. permit application fees collected under Section 29015 Water Code. Costs recovered under Section 91-113F of the Hazard Oil Gas Well Waste Generation Fee collected under Section 91-605 of the Oil Field Cleanup Regulatory Fee for the oil collected under Section 81-116. Oil Field Cleanup Regulatory Fee for the gas for the collected under Section 81-117. Fees are reissued certified collected under Section 91-707. Fees collected under Section 91-1013. Fees collected under Section 89-088. Fees collected under Section 91-142. Fees collected under Section 91-654. Costs recovered under Section 91-656 and 91-657. Fees collected under Section 81-052-1. Fees collected under Section 89-024 and 89-206. And legislative operations, any surcharges collected under Section 81-070. And fees collected under Section 91-0115. Fees collected under Subchapter E, Chapter 121, Quality Utilities Code. Fees collected under Section 270321 Water Code. Fees collected under Section 81071 and money collected under Section 81021 Acts added in 2011, amended in 2013 and 15 and 17, 19. All right. Reenacted and amended in Acts 2019, Section 81068. Purpose of the oil and gas regulation cleanup of the fund, money in the oil and gas regulation cleanup fund may be used for the commission of the in support of the agent for any purpose related to the regulation of oil and gas development, including oil gas monitoring, inspection, oil gas remediation of the oil gas well plugging, the study of the evaluation of electronic, extra of the geological data, surface of the encasing of the depths of the necessary of the protect usable groundwater in the state. Administrative of the pipeline safety regulatory program, public information, surface related to these activities, administrative costs, and state beneficial personnel involved in these activities. Acts added in 2011, amended in 2013. And then we're going to pause for a second. All right, Section 81069, reporting and progress and meeting performance goals for oil gas regulation cleanup fund of the Commission for the legislative operation required for the process shall establish performance goal for the oil of the gas regulation cleanup of the fund for the next biennium. Include the goals for each state of the financial year of the biennium for the number of years. Orphan wells to be plugged in the state managed funds. The abundant managed states of the site of the investigated assess the cleanup of the state funds. And 3, surface locations to be remediated. The Commission shall provide quarterly reports for the legislative budget, and report shall include following information with respect to the period since the last report was provided, as well as the cumulative of the amount of the money deposited on the oil of the gas regulation cleanup fund, amount of the money spent from the fund for purpose described in subsection A, and the accounts of the fund of the Commission progress with the meeting of the quarterly performance goal of the establishment in subsection A, and number of the orphan well for the plugged and state managed fund for the abandoned site. When the investigated for the success of the cleanup of the shape of the funds for the surface location for the mediated for at least 5% less than the number projected for the applicable goal established under subsection A for the explanation for the reason for the variance, and to any additional information data requested in the writing of the legislative budget board. 3, the Commission shall submit to the legislator make available to the public annually report with the reviews extent of which the money is provided under subsection 81067. Has enabled the Commission to be better protect the environment through the oil field cleanup activity. The report must include the performance goals established under the subsection A of the state financial year for the Commission, progress in meeting the performance goal with the number of the orphan well for the plugged and state managed funds and the abandoned sites of the investigated and assess the cleanup with state funds or surface the location remedial at least 5% less than the number of the projected applicable goals established under subsection A of the explanation for the reason for the variance. 2, the number of the orphan wells plugged within the state managed fund by region, the number of the wells orphaned by the region. 4, the number of the inactive wells not currently complying with the Commission rules by region. 5, the status enforcement proceeding all the wells in violation of the Commission rule for the period during which the wells have been in violation by region which wells are located. Number of the surface location remediated by the region of the detailed accounting with expenditures of the money found with the oil field cleanup activities include the expenditure of the plugging of the orphan well of the investigation, assessment, cleanup of the abandoned sites of the remediation of surface location, the method of the wish for the common surface of the priorities, but which determine in order which the orphan wells are plugged. 9. A projection of the amount of money needed for the next biennium for the plugging in an orphan well with investigation, assessing, cleaning of the abandoned site with the remediating surface locations, and 10. The number of sites successfully remediated under the voluntary cleanup program or subsection O, Chapter 91, or region. Section 8107, 0. Establishment of surcharges and fees, except for the provided subsection B of the Commission by the rule shall provide the imposition reasonable surcharge of the necessary for the fees and the of the Commission required to be as accredited for oil, gas regulation cleanup funds provided in 81067, the amount is sufficient to enable the Commission to recover the cost of performing the function specified in Section 81068 with the fees and surcharges. The Commission may not impose the surcharge any of the oil field cleanup regulatory fee and the oil collected under Section 81116, oil field cleanup regulatory fee on gas collected under Section 81117. The Commission by the rules shall establish the methodology for determining the amount of the surcharge that takes into account the time period required for the regulatory work associated with the activity in connection with which the surcharge is imposed. 2. For the number of individuals and entities from which the Commission area and the cost of them may be recovered, the effect of the surcharge of the operators are as all sides of the measure of the number of the oil and gas wells operated with the balance of the oil and gas regulations cleanup fund. Any other factor for the Commission determined to be the important fare of the equitable imposition of the surcharge of the Commission shall collect the surcharge of the charge on a fee at the time of the fee is collected. The surcharge collected under section and shall be deposited at the credit of the oil and gas regulation cleanup fund as provided in Section 81067. 81067. A surcharge collected under section shall not be exceeded the amount of the equal than 185% of the fee in which it is imposed. Acts ended in 2011. 81071. Pipeline safety regulatory review for the Commission by the rule of the established pipeline safety regulatory review of the BSF for the permit of the registration for pipeline. Under jurisdiction of the Commission, pipeline safety of the regulatory problem of the Commission may establish the fees to be assessed annually against permit of the registration holders as well with the individual fee for the new permit of registration, permit of the registration renewal, with the permit of the registration amendments. However, the fees may be in amounts of the aggregated are sufficient to support all pipeline safety regulatory programs. Costs include 1. Permitting registration cost for the 2. For the administrative cost for the cost of the employee's salary and benefit for the Commission. By rule, must be established by the methods by which fees will be calculated, so that the fees amount will reflect the time spent with the costs incurred to perform the regulatory work associated with the permitting or the registered pipeline with effect. The required fee for the operators also have the other factor for the Commission determines over the importance of the fair imposition of the fees for the Commission may be the base of the fees for any factor for the Commission considered necessary to efficiently, fairly recover the pipeline safety regulatory program. And its costs include length of the pipeline number, the number of new permits of the registration permit, the registration renewal permit, the registration amendments within the number of the pipeline system. Commission may by rule but establish reasonable late for the payment penalty for the fee of the charge under this section. The authority provided by this section, in addition with the authority provided in Section 121.211, a utility code for the Commission shall consider that any fees to be assessed under this section, and establishing the fees to be assessed under the section, a fee collected under the section shall be deposited for the credit in the oil gas regulation cleanup fund as provided in Section 81067. At Acts 2017. Section 81072, verification by contractors. In this section, the E-Verify program has been means of the signed by Section 673001 Government Code. Commission may not be awarded contract for the goods, or for the stay of the contractor, only for the contractor or any of the subcontractor registered for the participate with the E-Verify program. Provide employee information to the contractor, any of the subcontractors shall continue participating in the program during the term of the contract. Commission shall develop procedures for the administrator of the E-Verifying program under the section Acts dated 2017. Alright, text section as added in Acts 2021, and first text section added in 2021. 81073 for the critical natural gas facility, any of the Commission shall collaborate with the public utility of the Commission with the tax to adopt for the rule of the established process of the designate certain natural gas facilities and even associated with the provided with the natural gas and stay with the critical customer with the critical gas supply with the energy emergencies. Rule must establish criteria for the designation person who is on operating facilities under the jurisdiction of the Commission. Under Section 81051A, that engage the activity under the jurisdiction of the Commission. Under Section 81051A, who must be provide critical customer, critical gas supply information with the defined of the Commission on it, even described by the Section 83807-4B1 utility codes. Consider essential operator elements within the defined critical customer designation, critical gas supply with information purpose of subdivision 1, including natural gas production, process, transportation related produce, water handling with a disposal facility with delivery of the natural gas generated to electrical energy. 3. Require that only facilities that are prepared to operate during the weather emergencies may be designated with a critical customer under this section. Added Acts 2021. Text section added in 2021. Section 81073 of the critical natural gas facility entities. Commission shall collaborate with the public utility commission with the text of the adopt the rules established process that designate with a certain natural gas facility within the entities associated with the providing the natural gas in the state with a critical customer. Critical gas suppliers during the energy emergency. The rule must establish criteria for the first before designating the person who owns the operator of the facility under the jurisdiction of the Commission under Section 81051A that engage the activity under the jurisdiction of the Commission under Section 81051A, who must provide electrical critical customer with the critical gas information as defined in the Commission with the described by this section. 38074B1 Utilities Code. Consider essential operational elements with a defined critical customer designation, critical gas supply information purposes of Subdivision 1, including natural gas production process, transportation related produce, water handling disposal facilities, and delivery of the natural gas generators to the electrical energy. Alright, subchapter D, witnesses. Incrimination testimonies 81091. If the witness failed to refute the appeal of the being summoned for the answer to any of the question he is or he has to do for the record of the data required by subpoena. To claim the testimony taken for the incriminated the person given this does not excuse the witness by testifying, producing the record of the data of the evidence or testimony may not be used against the person or in the trial with any of the criminal proceedings. Acts 1977. 81092. The fee for the executing process of the sheriff of the unconstitutional execution process shall receive the compensation authorized by the Commission. 81093. Depositions. In the matter depending on the hearing before the Commission of the Division of the Commission of the interested part of the produce of the testimony of the witness of the written of the oral deposition, instead of the compelling with the personal attendance of the witness for the purpose of the Commission, it may issue the Commission for the other purposes necessary of the and take a disposition. Deposition shall be taken to the extent of the applicable to the greatest extent and taught possible in accordance with the provision of the Texas Rule of Civil Procedure relating to the written and oral procedures acts added in 2009. Alright, subchapter 3, subchapter E, fees. 81115, apprehension of the Commission for the Oil and Gas Fee Regulation, cleanup purpose of the money appropriated for the Commission under the GAO and General Application Acts for the purpose described in Section 81068 shall be paid from all oil gas regulation cleanup fund with the other fund indicated by the appropriation. Acts 1977, Acts 2011. 81116 with the oil field cleanup regulatory fee on oil field cleanup regulatory fee with imposed for the crude oil, petroleum produced for the save of the amount of the 5/8 of the 1 cent with each of the barrel 42 standard gallons. The fee is an addition of the two and independent of any of the liability with the tax imposed under Chapter 202 of the Tax Code, except for the provided subsection D with this section, Chapter 202 of the Tax Code, apply with the administrative with the collection of the fee. The penalties provided with this chapter apply with any of the person who failed to pay report the fee. The exemption reduction set out in the Section 202.502 for 202.554, 56, 57, 59, and 60 tax codes do not affect with the fees imposed by this section. Alright. E. Proceeds from the fees excluding any of the penalties collected with the connection with the fee with the shall be provided with the oil with the gas regulation cleanup fund that is provided in Section 81067, amended Acts for 1991, amended to the Acts 2001, and amended in 2005, 2011, 2015, 2019. Section 81117, the oil field cleanup regulatory fee on the gas. Oil field cleanup regulatory fee that imposed on the gas initially produced the save of the state with the amount of the 1/15th of a cent. 1 cent for each 1,000 cubic feet. These fees, in addition to the independent of any of the liability for the tax imposed within Section 201.052 of the tax code, except for the provided in subsection D of the administrative collection and enforcement of the fees, is the same as for the tax imposed on Section 201.052 tax code. The exemption of the reduction set out with the Section 201, 053, 57, 58, and 60, the tax codes do not affect with the fees imposed within the section. Proceeds from the fees, excluding any of the penalties collected for the connection with the fee, shall be deposited to the Oil, Gas, Regulation Cleanup Funds as provided in Section 81067, added in the Acts 1991, amended in Acts 2001, 2005, 2011, and 2019. Alright, subchapter 5F, campaigning. 81-151 penalty for campaigning. A person who receives salary for the funds provided within this title who used at the time our state-owned automobile for campaign purposes for purpose of the further candidacy of his employer, any other candidate for the state office is guilty of a misdemeanor. On a conviction shall be fined with not less than $100 no more than $500. Shall be confined in jail not less than more than 30 no more than 90 days. So I'm going to read that one more time. A person who receives salary from funds provided under this title will use his time in the state-owned automobile for campaign purposes or for purposes further candidacy of his employer. Any other candidate with the state office guilty of a misdemeanor and or conviction shall not be fined less than $100 no more than $500. Shall be convicted and fined in jail for no less than 30 days, no more than 90. Alright, 81-152, discharge ineligible. The person found with guilty under Section 81-151 over this code shall be discharged immediately, but the position shall be ineligible for the employment by the state in the future. 81-153, setting civil complaint for the hearing. If a citizen for the state filed with a civil complaint with the district court with the Travis County charging the employee with the use of the time and state-owned automobile for the campaign purposes further the candidacy of the employer or any other candidate for the state office of the court shall be the complaint of the hearing at the time not less than 10 and no more than 20 days after the date when the complaint is filed. Acts 1977. Section 81-154, notice to the employee of the court shall have the notice of the hearing served on the employee against from whom the complaint was filed with at least 5 days before the date of the hearing. Court's order at the hearing if the court determines the employee has used his time or state-owned automobile as a charge in the complaint, the court shall certify to the fact that the department, agency, commission, employee with the person that orders for the employee with the immediate discharge. And 81-156, appeal with any person against whom the charges have been filed within the time of the appeal with the court's appeal, but with the pendency of the appeal does not suspend with his discharge. And that was your Railroad Commission of Texas, Title 3, Oil, Gas, Subtitle A, Administration 81, Railroad Commission of Texas.